Hey, welcome back. It's Zachary Harris. I'm a civil litigator in Winston-Salem, North Carolina, and I'm back at my favorite new pastime, which is giving my gut reaction to questions posted to Reddit's r/legal advice. I'll be treating this as though these folks walked into my office in North Carolina, told me their story, and asked what I thought. Let's take a look. My 3-year-old son busted his head open at daycare and had to get stitches. Daycare refuses to show the recording. My 3-year-old son fell at his daycare today, and it was bad enough that he had a deep gash in the back of his head and had to get stitches. They originally told me he fell on the metal playground and they could not show me the video of him falling because other kids are on the recording. My sister, who has a connection there, called a little later and told her he was pushed. Okay, I guess they told her that he was pushed. Even though they told me repeatedly he fell on his own accord. He should have been supervised in the first place. Yeah, true. Are they allowed to deny me that footage of my son getting his head busted open? The longer I think about it, the more agitated I become. This is a common problem that we have where there'll be some sort of injury in a case that's been captured on surveillance footage, but we don't have access to the footage as the plaintiff. It's not our camera. We can't just walk in and take it from them. Really puts us at a disadvantage. The high-level answer to her question of can we get the footage is no. Generally speaking, they're not under any obligation that I know of to hand over the footage without any sort of legal order. The only way you get a legal order like that is by filing a lawsuit. We would have to begin by filing a lawsuit for the child's injuries, and then through what's called discovery, we would request the production of the video. The daycare saying, hey, we can't show it to you because there's other kids in the video, I don't think that's based in anything. I think that's probably an internal policy. Really, it's probably they just don't want to show it to you because they know what happened in the video, but I don't think they have either any protection because there's other kids in the video, nor any obligation just to show it to you. As far as a claim against the daycare, first of all, there's some degree of risk, I think, when you send a child to daycare. Kids are kids. They do get hurt. Being pushed by the other child is interesting because it's not likely to give rise to a claim against the other child, who's, probably 3, or the other child's parents. The poster has identified the right question, which is there any claim against the daycare for failing to properly supervise the kids playing? There may be. I don't think this is a case that I would take. I think, the damages are meaningful, but they're not lifelong. Getting stitches, obviously a child getting hurt is really devastating, but it doesn't sound like this kid is going to need lifelong care to where the damages we're talking about are in the millions of dollars. So given that, I think that a lot of members of a jury are going to be very sympathetic to people running a daycare, particularly parents. I think a lot of them are going to say, look, kids get hurt. That's sort of how it goes. I think this would be a tough case to take. My grandparents just found out that half their property isn't theirs 40 years later. We are devastated. There's too much to read. I'll just tell you what it says. Basically, grandpa and grandma bought this house, this property, 5-acre property, 40 years ago. Recently, they learned, according to the county maps, really the only parcel they own was really only 2 acres, not 5. The barn, for example, is on their neighbor's property. The folks at the county office said it's probably gonna cost you $100,000 to get this fixed. So the question that the poster has is, can my grandma get her money back? I mean, they paid thinking they were buying 5 acres. How is it possible they now just only own 2? This is exactly the reason for a legal doctrine called adverse possession. In short, the rule says that if you have possession of a piece of property and you use it like it's your own for long enough, the law will just say it's your property. It's exactly to address situations like this. I had a case like this. 40 years ago, grandpa bought this house thinking they were buying it with certain property lines. Everyone treated the property as though those were the property lines. It's only 40 years later that it's discovered actually, according to the survey, those property lines are wrong. But we've all treated it for 40 years like she owned the land, like she owned the property. And so our law is going to say, look, regardless of what the survey said 40 years ago, we are going to say now the new property line is the line you all were using. That's it. That's the new line. Grandma bought 5 acres 40 years ago. She owns the 5 acres now. The only way you get there, though, is by filing a lawsuit for what's called adverse possession. The post says that was going to cost $100,000. I don't think it would cost that much, and I think that's a lot. But it would cost thousands of dollars, if not tens of thousands of dollars, to bring in order to get the property line settled. The big issue is the poster says that grandma, has since sold the property. If she sold the property, she's out of it. She's got no claim anymore. Really, there's nothing she can do about this. She should have called a lawyer before selling the property in order to get this all cleaned up. How do I sue asset prevention for slamming me on my head, putting me in a coke hold, then handcuffing me in their office until they find out I paid for everything they said that I stole? This all happened at Nordstrom in the mall right as I exited. I have a full video for evidence showing him slam me to the ground, and then they dragged me to the office. They gave me my stuff back and said I'm free to go, refusing to answer any more of my questions. You may have wondered this before. What gives Walmart or Target or Nordstrom the right to detain people who are suspected of stealing? They're not police officers. Why do they have the right to say, come back with me, no, wait for the police, you can't leave? But they do, they have that right. It is called shopkeeper's privilege. And it's a statutory right that they have where if they suspect someone of stealing, they can detain that person until that's resolved. Now, that doesn't mean they get to do whatever they want. They don't get to put you in a chokehold. They don't get to slam you to the ground. Most loss prevention folks I know of, because I've worked on a case involving loss prevention before, the rule is you don't touch the suspected shoplifter at all. You don't touch them at all. It's like the number one rule, you don't touch them. And there's a lot of reasons that you don't touch them. If you touch them, they're gonna fight back. If you touch them, they're gonna run away. And you don't know who else is going to get hurt in the process of them fighting you or running away from you. Good odds that they're gonna run in and knock over one of your other customers, or they're gonna swing at you and miss and hit someone else. In fact, I think that some stores even have a rule that says you don't get between them and the exit. That all you could do is say, sir, would you mind coming back to the office with me? Putting you in a chokehold and slamming you to the ground, handcuffing you, that all is really, really improper. We had this problem before. Makes me doubt whether or not this really happened. But if it did happen, I think they've got a really good claim. The problem on the claim, this is always a problem on claims like this, are damages, which is the extent of this person's injury. It doesn't sound like they've got any lasting injuries. It's hard to recover what's called compensatory damages or economic damages because he doesn't have a lot of medical bills. He's not injured for a long time. So it's sort of hard to put a value on a case like this. But you still can. And I think a jury might be incensed enough, angry enough at the conduct of these security folks to really hit them pretty hard. And so I think it's a good case. The fact that there's video is huge. That would be the decider for me. I wouldn't take this case without video, but since there's video, I would take it. Can I be sued for my 16-year-old son driving his friend's car and crashing it? My son's friend Jay let my son drive his car and my son crashed on the freeway. My son does not have a license and the car was in his friend Jay's mother's name. The police took the car, it was totaled, and gave my son 2 tickets, one for driving with no license and another for reckless driving. The mother of Jay contacted me and let me know that her insurance company will be suing me. My question is, can I be sued for this? The car that was crashed probably wasn't even worth $1,500. It was like a 2005 Taurus or something. Hey, don't knock 2005 Tauruses. So the question is, can mom be sued? I say this all the time. You can be sued for anything. The question isn't, can you be sued? The question is, will the lawsuit stand? And by that, I just mean that anyone can go into the clerk's office, write someone's name on a complaint, file it, and boom, that person's been sued. They're gonna get it kicked out very quickly if it's not a valid claim. The person filing the suit could be in real trouble for doing that, but you can be sued. The question is, can mom be found liable? And that's a really, really fact-specific question. Based on these facts, I would say no. It's unlikely that mom can get sued unless there is some sort of independent misconduct by mom. So it's not enough that your son did this, so you're responsible. It's gotta be that you, mom, did something that resulted in this crash. So I've had this situation before where I have sued a parent after they gave their son a car to drive. The son was gonna go to a party, he was in high school. Everyone knew what was gonna happen at the party. They all knew there was gonna be drinking, and the son's parents let him take their car to the party. And there was this really horrible, tragic wreck. In that case, we did sue the parents. And it's what's called negligent entrustment, basically saying, you guys should have known. You probably knew, but you certainly should have known he was gonna drink and drive. And if you know that's gonna happen, you can't enable that. You can't entrust your car to somebody who you have reason to believe is gonna do that, and you did. Doesn't sound like that happened here. Mom didn't give the son the car, didn't probably know that the son was going to drive the car, had no reason to know that the son wasn't going to be a good driver other than the fact he doesn't have a license. So I think mom's in the clear. The son's not. The son could be sued, but also it's $1,500 if that's the value of the Taurus. And that's not a ton of money. I mean, it is a lot of money to a lot of people, but it's not $15,000. It's not $150,000. It's not $50 million. And so I think it's likely the insurance company is going to say, we're not hiring a lawyer over $1,500. We're just going to move on. So I think the odds that she gets sued or even that her son Jay gets sued are pretty low. So there you have it. Those are my hot takes to these questions here on Reddit. These are always so interesting to read because it shows the variety of ways that people end up interacting with the legal system. I hope you found these interesting, and if you did, please let me know and encourage me to keep making them. See ya.